Disgraced singer and convicted child sex offender Gary Glitter has had his bid to be released from prison rejected by the Parole Board. In this video, I'm going to briefly explain why Gary Glitter is in prison despite having served half of his sentence. I'm then going to talk about the test that the Parole Board would have considered when determining whether or not to release him. And then finally, I'm going to outline how the Parole Board came to the decision not to release Gary Glitter. Welcome to my channel, Andy on Crime, where I talk about high-profile criminal cases and other aspects of criminal law in England and Wales. So to briefly outline the facts of this case, Gary Glitter was convicted in February of 2015 of 6 child sex offences against 3 victims. There was 1 count of attempted rape, 4 counts of indecent assault on a child under the age of 13 against 2 victims, and then 1 further count of sexual activity with a child under 13. In total, he was sentenced to 16 years in prison. Now, one of the first videos that I ever did on this channel was to explain why he would have been given a much longer sentence had he been convicted under current laws. So please check out that video, and you can see the quality of the content has hopefully improved since that video was made. He was released automatically at the halfway point of his sentence, as is normal in all what are known as determinative sentences. These are normal sentences that are awarded to most people in court that are not life sentences or extended sentences. He was then subjected to licence conditions which he had to abide by, otherwise he would be liable to be recalled to prison. Now, in March of 2023, Gary Glitter was indeed recalled to prison following allegations that he had sought to access the dark web and had viewed inappropriate material online in breach of his licence conditions. Having been recalled to prison for breaching his licence conditions, Glitter would have to go before the Parole Board in order for them to grant him release. Now, the test that a Parole Board has to consider when deciding whether or not to release someone after they've completed their minimum term or when they are eligible to be considered for parole is that they are satisfied that it is no longer necessary for the protection of the public that a person should be confined. So it's not purely about the seriousness of the offence, although that can be a relevant factor in considering whether they are safe to be released. It's really looking at what steps, if any, an individual has taken in prison to atone, rehabilitate, or take any measures to take responsibility for the offending which placed them in prison in the first place. If a person is deemed to meet that test, that they are no longer a danger to the public, then they will be released. If they do not meet that test, however, then they will be permitted to reapply when eligible on a date set by the Parole Board. In coming to their decision, the Parole Board, who held a private hearing which was not open to the public, stated that Gary Glitter continued to show a lack of victim empathy. Now, the summary of the Parole Board panel's decision said that it found evidence that at the time of the offending and whilst he was on licence, Mr. Gadd, that's the real name of Gary Glitter, had a sexual interest in underage girls. And it stated that Gadd had not taken part in any programme in prison to address his offending and continues to deny having a sexual interest in children. Now, the decision published by the Parole Board today, Wednesday the 7th of February, continued after considering the circumstances of his offending, the lack of progress made while in custody and on licence, and the other evidence presented at the hearing, the panel was not satisfied that release at this point would be safe for the protection of the public. Rather, the panel considered that Mr. Gadd was appropriately located in custody where outstanding levels of risk could be addressed. Where does that leave Gary Glitter now? Well, apart from in prison, of course. Well, he will be informed when he is next eligible to be considered for parole, and he will be entitled to apply again. However, looking at the reasons for the rejection of his application for parole, it seems unlikely that he will be considered safe for release unless there is a dramatic change in his attitude towards his offending and he engages with measures aimed at rehabilitating him, if indeed he is able to be rehabilitated. If he is continued to be refused parole, then he will be released at the end of his sentence sentence of 16 years, which means he will leave prison in 2031 at the age of 88. That's all for this video. If you do have any comments, then please drop them down below. If you did enjoy this video, then please do give it a like. And if you'd like to see more from me, then please do subscribe to my channel. Thanks for watching. Take care.